is Face Diaspora, a platform for conversations on Eritrea. Your host, Russom Mesfun. Ladies and gentlemen, on the phone with me is James Yap, an attorney representing the three Eritreans who are suing Nevsun, a Canada-based company, for alleged human rights violations, including cruel, inhuman, and degrading treatment at the Bisha mine in Eritrea. Nevsun has declined to comment on inquiries pertaining to the lawsuit. James Yap, thank you for being available to talk with us on rather very short notice. James, can you explain to us what the lawsuit is in reference to as far as the Nevsun firm is concerned?
Sure. Well, Nevsun is a Canadian mining company that has a gold mine in Eritrea. It's a very successful mine. Since starting production in 2011, it's generated $1.6 billion US in revenues. Now, it emerged a few years ago that in order to build the mine, Nevsun hired Sagan Construction Company, which is a company that's affiliated with the state and more specifically with the ruling party, with the PFDJ. It hired this company to perform construction on the mine, and it came out that Sagan Construction Company was using forced labor to accomplish the construction work on the mine. What this suit is doing is it's a suit on behalf of the victims of the forced labor who were forced to work at the Bisha mine. That's the name of the mine. The victims who were forced to work at the Bisha mine, trying to get some kind of redress for them because they worked at the mine under duress and under very harsh conditions, long hours, very low pay, very meager food rations, and also under the threat of torture and imprisonment. And I hardly need to go into the horrors of the forced labor program as operated mostly through the National Service Program in Eritrea. It's generated substantial numbers of refugees who have fled the country from Eritrea and led to, in my opinion, some disastrous social conditions inside the country. And so this lawsuit is an attempt to hopefully get a little bit of redress for some of the victims who've gone through that. Now, the lawsuit, as I mentioned, is against the Canadian company. It's unfortunately, we can't sue the government of Eritrea because there's something in law called the State Immunity Doctrine or the Sovereign Immunity Doctrine. And that's the rule that says that you can't sue a foreign government in another country's court. But what we can do is we can sue the Canadian company, which is subject to the jurisdiction of Canadian courts, their involvement in these atrocities.
Now, these three people, are they just representing themselves, or they're actually representing a broad section of people who were employed by Sagan?
Mm-hmm. Yeah, well, what we're doing is we're using a procedural mechanism called a representative action, and what that does is it allows one person or a small group of people to, shall we say, launch an action sort of in their name, but on behalf of not only themselves, but everyone who is in a similar circumstance. And that's what we're doing here. So it is an action, a lawsuit that is being brought on behalf of all people who were used as forced labor at the Bisha mine.
And so you said that you're actually trying to secure a redress. What is it meant when you say redress? What does that look like as far as getting any kind of resolution is concerned on the part of either Sagan, the government, or the Nevsun for that matter?
Well, the way the law works is that the law only knows one form of redress, and that's damages. That's money. That's the only thing really a court can do for you when you bring a case like this. They can't order, say an apology, or they can't really order, the only the language the court speaks basically is money. And now within the framework, however, of a lawsuit, I mean, there's flexibility. For instance, if you negotiate a settlement, you can sort of come up with special terms, such as, like you could sign a settlement saying, the company agrees to implement strong, rigorous, independent monitoring to ensure there's no longer any forced labor at the mine, or better yet, the company agrees to withdraw its support from the Eritrean government altogether. In terms of what we're seeking from the court, all you can ask for is damages. And there is some leeway, again, if there's a settlement, to try and include some additional terms. And also, if there is some kind of settlement, and say it involves an amount of money and it involves, additional terms, hopefully it will also send a strong signal to other Canadian companies and other companies generally that they will be held accountable if they do business in Eritrea and get involved in the kinds of atrocities that this government is committing.
So, James, is the idea to correct the practices of this firm, or actually force it to remove itself altogether from the country because of the larger scale repressive practices underway in Eritrea as a whole?
As a lawyer, my professional duty is to represent the client and to represent the best interests of the client, and so that's sort of where my first loyalties are. But putting that aside, there's certainly some hope, again, that this is going to affect some kind of change, whether it involves Nevsun correcting its practices or maybe the regime. Who knows, right? The regime correcting its practices and saying, okay, we're not going to use forced labor anymore. Certainly, this is part of the hope on our part, that there's going to be some sort of remediation taken to correct this, and it won't. We're not just hoping that the companies will just pay some money, make it go away, and then keep on doing the same thing. But we hope to make it impossible for companies to viably continue engaging in these kinds of practices.
James, for the record, the Nevsun company has not responded to inquiries about the lawsuit. Have you made an attempt to resolve the situation with them directly?
Well, we filed the lawsuit, and the lawsuit, as you know, was filed a few days ago. And so what that basically means is the ball is in their court. Now, they haven't responded to media inquiries, but they have released a statement. The statement has said that they deny the allegations and they intend to defend the claim vigorously in court. So that seems to be the attitude they're going to take. On the other hand, they may approach us and see what it would take to make this go away, basically. The ball is basically in their court.
Could the firm, Nevsun, actually claim that, look, we have a contract in the country, and we have subcontractors, and whatever the country gives us, we receive, so we should be absolved of all responsibilities? What are the chances of getting any resolution from this situation?
It's interesting. One of the first, or actually the first case involving a company that went to trial for involvement in the use of forced labor was at the Nuremberg trials, right, where they were trying Nazi war criminals from Germany, and there were some companies there that had been involved in the use of forced labor supplied by the Nazis. And in the Nuremberg trials, a common refrain among the defendants was Befehl ist Befehl, which is German for a German phrase basically meaning we had no choice. We did what we were told to do, right? And that defense did not the judges at Nuremberg, and we would argue it shouldn't impress judges in Canada 60, 70 years later anymore. At the end of the day, they did have a choice. If they could not operate this gold mine secure in the knowledge that forced labor would not be used, then they had the choice to just not operate the gold mine and walk away. Instead, they chose to go ahead with the operation anyway, and so they have to bear the consequences of that.
James, what are the steps from this forward? What happens from now, and what are the likely possible ideal resolutions that you anticipate?
Well, like I said, we've filed the claim already. We've given them notice of the claim and acts that are alleged and the case against them, and it's in their, the ball is in their court to respond. They may do that in any number of ways. They may bring some procedural motions. They may try and settle the case. Eventually, they may try and their statement indicated that they deny the allegations and will defend the claim vigorously. So they may try and contest the evidence that we have. That's fine. I mean, we're pretty confident in our evidence. We're pretty confident we can establish what happened at the mine. But yeah, it's right now the ball is in their court. It's to choose how they want to respond.
James, there are, I'm sure, quite a few Eritreans listening to this conversation. How would they be able to contact you should they have a case that actually warrants your own very attention?
Absolutely. If there's anyone out there who feels that they have relevant information, or maybe if they have their own claim against this company, then they can contact me. Is email a good way for your listeners?
Yes, we could actually post that email or a number or any avenue for that matter.
Sure, they can contact me at james.yap, Y-A-P, @gmail.com.
James, why is your firm taking an interest in this? Are you doing this on pro bono basis? Is this a humanitarian gesture on your part? Or you're actually being paid by some organization that we are not aware of?
Okay, now that question is a little tricky because it isn't one firm that is doing this case. It is a combination of firms, and I really am not in a position to speak for all of them. What I could perhaps say is that there is certainly an element of this case where we're doing it because we believe it is the right thing to do, and we believe it is something that needs to be done by somebody, and we just have a personal personal belief that this is what we should be doing. I think that's something that's one thing that I think is shared by all the members of the council team. For the plaintiff side, because it is a team and we're all working together, and it's we're all pooling our resources because it's not an easy case. It's a complex case with a lot of nuances, and it's taken a lot of work to get to this point. It's a bit of a novel case, a bit experimental. There are some legal theories we're testing out that are sort of unproven in Canada. These kinds of this kind of litigation there's not really an established precedent in Canada for suing a Canadian company for involvement in human rights abuses that took place in another country. So it's a whole team of lawyers, a very diverse team of lawyers working together. But I think we all certainly share a conviction that what we're doing is the right thing to do, and a belief in the work that we're doing.
James, I cannot thank you enough for availing yourself on very, very short notice. Can we count on you to communicate with us and keep us posted on all developments pertaining to this case? As you can imagine, we're all interested in this.
Absolutely, Russom and thank you for your interest.
And that was James Yap, the attorney representing 3 Eritreans who are suing Nevsun, the Canada-based company, for alleged human rights violations. Nevsun has not been available for comment. Thank you for listening to our program.